Can you hear the background noise, like cars?
No.
Okay. Okay, we're admitting folks.
Good.
Hi, everyone. We'll start in just a minute.
I thank you.
Hi, everybody. We'll start in just a minute. Folks are joining. Okay, we can go ahead and get started. Great to see you all. Thanks for joining us. So tonight we are talking about ethics. So I believe I know most folks on the call. I'm Jen White. I'm the Executive Director of Arise Immigration Services, and we have a dual mission. We provide free legal representation to asylum seekers in Pittsburgh, and then training and mentoring to folks around the country as we work on our cases together. So tonight's training really evolved out of a lot of ethical issues that we've confronted as we work on our cases and that we talk about because we see ethical issues in this field a lot. So Danny White, who I'm married to, is joining us. Danny prosecutes lawyers for ethical misconduct. So if you hear of an attorney being disbarred, his office handles those matters. And he's a super valuable resource for us because immigration law is just filled with so many opportunities to observe ethical issues and to commit misconduct. So thanks for joining us, Danny. We have kind of a loose agenda, mostly based on what you all have told us you want to hear about, but I'll pause frequently so you can add your comments and questions. So Danny, take it away. We will start with unauthorized practice of law.
Great. Thank you so much for having me. I appreciate being welcome back again. Before I get started, my get a little disclaimer in here first. I'm with the Office of Disciplinary Counsel here in Pennsylvania. My remarks tonight are my own. They don't necessarily reflect my office's position on specific matters, nor are they legal advice for any specific situation that you may be confronting. So I think we're going to start with unauthorized practice of law, um, which is a little difficult to define. There are a number of different definitions out there. I'll give you two. One is in Pennsylvania. This is a provision in the Judiciary Code, Title 42, Section 2524. It describes a crime, misdemeanor, anyone who shall practice law or who shall hold himself out to the public as being entitled to practice law or use or advertise the title of lawyer. And then in the Code of Federal Regulations, which is more specific to immigration practitioners in particular, this is Title 8, Section 1001.1I. The term practice means exercising professional judgment to provide legal advice or legal services related to any matter before the Executive Office of Immigration Review. This includes, but is not limited to, determining available forms of relief from removal or protection, providing advice regarding legal strategies, drafting or filing any document on behalf of another person appearing before EOIR based on an analysis of applicable facts and law. So that's more of a typical definition of practicing law, the application of facts to specific legal principles. Uh, so yeah, I think Jen's going to talk about how they handle that at Arise.
Yeah, so I'm putting the federal regulations in the chat so you can look them up yourselves. But yeah, so this is super important for immigration practice. So there's two categories of folks who are authorized to practice immigration law. There's lawyers, of course, and then there's Department of Justice accredited representatives who are authorized through the DOJ to practice immigration law through recognized organizations, like Arise, for example, is one of those organizations. Um, so it's just two categories. Everyone else cannot practice immigration law. But it gets gray, as you could kind of tell from what Danny was explaining. What does practicing law entail? So we are on kind of one end of the spectrum. We're very cautious. We closely supervise all of the legal work just to make sure that it's of the highest quality and that we're running each big decision by multiple decision makers so that in a time like this, when clients are really at risk, we are as careful as possible. So all that's to say, anyone who volunteers with us is going to be closely supervised. And then, of course, there's four of us who are authorized to practice law, so we can do that. But we also have each other view our work and like review it and make sure that we are a sounding board for each other. So that's just a disclaimer for you, because I know many folks who come through like our trainings will work and volunteer with other organizations. So that's something you want to look for is that close level of supervision for folks who are not authorized to practice law to make sure they're getting the oversight that they need. And even folks who are authorized, that they have appropriate supervision at the beginning of their practice so they can learn the ropes appropriately. So I'll pause there. Unauthorized practice, it's nebulous. People have different definitions. You'll hear different definitions as you attend trainings. Some people think that it involves filling out forms like immigration forms. Some people think that it does not. So I'll pause there. Comments, questions on unauthorized practice. Okay, so moving on to limited representation. So limited representation is what it sounds like. It is when you are not entering your appearance or representing the person for the full scope of whatever it is that they're trying to do legally. So, for example, for us at Arise, we enter a limited appearance in a couple of different types of matters. The big one being asylum applications. So, right now, the asylum world is just completely unpredictable in terms of when clients will interview for an affirmative asylum case. They could submit an application and be interviewed right away within a matter of weeks, or they could wait 10 plus years for that interview. So when we're dealing with that kind of unpredictability, it really helps to have an upfront conversation with your client and only appear on a limited basis or only have a limited representation agreement with them so that you're only doing a portion of their case as opposed to the whole case. So that's what we do right now. We can't commit to being on the hook for asylum cases for 10 plus years. That's just not feasible, probably for any organization right now, and especially for us as a small one. So you'll see that if you volunteer with us, what that looks like and what it means. But it does not mean compromising the quality at all. It just means being specific about what you're actually doing legally for the client. So Danny can talk about how you do that in an ethical way.
Sure. So there's actually a rule about this for attorneys in Pennsylvania. This is Rule of Professional Conduct 1.2C. It says a lawyer may limit the scope of representation if the limitation is reasonable under the circumstances and the client gives informed consent. Now, those rules are specific to Pennsylvania attorneys. They are modeled after the model rules of professional conduct, so other jurisdictions have similar rules. So a couple things there. Um, the limitation has to be reasonable under the circumstances. There's no specific definition of that. It's fact intensive. Each case will be different. The other is the client gives informed consent. Informed consent is a defined term in our rules. It's the consent of a person to a course of conduct after the attorney has explained two things: the material risks of that course of conduct and the reasonable alternatives to that course of conduct. So in the immigration world, if you're going to limit your representation, say you're doing, you're going to limit it just to asylum, no other forms of relief. So you would explain to your client, hey, there's a risk that you're eligible for other forms of relief that I'm not screening you for example. And a reasonable alternative is you go hire a lawyer and you pay them and they'll screen you for everything. So that's just an example. Again, it's fact intensive. Another thing to think about is this particular provision of the rules, it just says the client gives informed consent. There's other provisions of the rule requiring informed consent to be confirmed in writing. So technically, these rules don't require the client to confirm their consent in writing. But that's more of a bare minimum. I think best practices you would want to confirm that in writing, and you may want to do it several times during at the initiation of the representation in the retainer agreement, maybe even throughout the representation in the closing letter. And lawyers actually do this even if they don't realize it's what they're doing. When you sign a representation agreement, it might say something like, you've hired me for the trial. If you want me to handle an appeal, we'll have to sign a new agreement, figure out a new fee. Uh, any questions about any of that?
And a little bit of context for you. So, Danny prosecutes Pennsylvania attorneys mostly. There's some exceptions to that, right? Other lawyers who are practicing in Pennsylvania,
Correct. Our
but
jurisdiction
mostly.
is
Go
Pennsylvania
ahead.
attorneys or attorneys who are practicing in Pennsylvania. Correct.
So it's interesting to think about the rules that we're talking about here. So he's mostly referencing the Pennsylvania rules that bind attorneys. And those are pretty comprehensive. If you look them up, it's a long set of rules. He is also mentioning the Code of Federal Regulations, and those bind all immigration practitioners, meaning both DOJ reps and immigration lawyers. But the federal regulations are short. They are not very well thought out. Like, for example, they don't have a conflict of interest provision, which is what we're about to talk about. However, what we're talking about tonight is widely applicable in that from state to state, there are these themes that you'll see in the ethical rules that bind the attorneys of, each state. So these common themes are going to be relevant to you regardless of where you're located in the states. But thinking about what does this look like in your practice, the way we do it at Arise is I'm a Pennsylvania attorney, and then we have three DOJ reps who, of course, are bound by those like really short Code of Federal Regulation rules. So I am bound by these robust rules. Our other teammates are bound by like the short list of rules, but we apply both just to make sure that we are being um, as ethical as we can be. Our DOJ reps also look at the Pennsylvania rules to make sure that we're all complying. Emily, go ahead. I see a hand.
Yes, I had a question about limited representation on your asylum applications. When you enter your appearance in a limited capacity for your affirmative asylum cases, do you also get all of the notices as well for that asylum case, um, and including the interviews? Because I had a case where I was trying to do limited representation. And I wrote clearly in the G28 that it was just for the application submission and not the interview. And I continued to receive all the notices, including the interview notice, which is fine because I got the interview notice, I was available, and I went. But I'm wondering for future cases where I might not get the interview notice, how can I mitigate that, not being on the hook for the interview notice that's potentially 10 years down the line?
Yeah, that's a great question. And you're talking specifically about affirmative asylum, right?
Yes.
Okay, so there's multiple ways to do it depending on how you're filing. If you're filing online or if you're filing through the mail. Which one would be more helpful for you to talk about?
Via mail, because unfortunately most of my clients are UACs and USCIS only accept mail filings for those.
Okay, then just practically, because I don't think you're going to find in all of the instructions, like for the 589 and the USCIS instructions, I don't think you're going to find a clear answer to this. So what I would do is I'd make sure it's noted in the cover letter for whatever you're sending in very large font highlighted that it's limited appearance. And then you want to file a G28 like you're saying because you helped them. So you want to notate that for the government. We're ethically required to do that. I usually put just a little star explaining, there's a section where you put the form, the I-589, and then I just put a little note on the back page explaining exactly what I did. USCIS highly dysfunctional, they're likely to disregard all of that and send you the notices instead. At least though, then you can contact the client. I know none of us are signing up for this, right? It's additional work for us, but at least then we're more likely to get the notices than the client. So even if you're not on the hook, you can then let them know that they were scheduled. Sorry, that's a very unsatisfying answer, but that's, I think, the best that you can do.
That's okay. I
Galen.
really appreciate it. And I was just wondering if there was more information that I wasn't aware of, but that's really helpful. Thank you.
Yeah, of course. Do you have anything to add to that, Danny?
I do not know.
Okay. I'm just seeing if there's any other. Okay, let's move on to conflicts of interest. Oh, I'm sorry, there is one in the chat. Any
I have a
best
question.
practices for
No, go
clients?
ahead with that one.
Oh, okay, great question, John. Any best practices for clients asking questions outside the scope of representation? Danny, you want to take this?
Sure. So I usually see things after the relationships break down and it's the client complaining about the advocate. So that's usually the way I approach questions like this. And the best practice, the best advice I could give is make it clear in writing what the scope of the representation is, so that when someone like me comes and asks questions, you can, it's not just your word, it's I sent them this letter, they signed this contract. And if you know sometimes clients will need you to say it more than once, and if the answer to their question is I'm sorry, I can't answer that, that's outside the scope of my representation, we've talked about this, maybe you have to say it more than once, but my advice would be to say it in writing, and maybe say it in writing more than once as well.
Thank you. That helps.
Okay, Yahaira, I think you had a question.
Yes, for those respondent that they are out of the year mark. For the question 5, you have to have extraordinary circumstances, reasons, and but you explain to them, and to be honest, they found out like I want to submit the application, I didn't know, nobody told me, um, or whatever the situation is, but they pass the year mark, but you still can like help them. I heard people saying that's fraud. Is that
Hmm.
okay? How is the best way
Yeah,
to
it's a
handle
great
that?
question. So if you're filing for asylum, if you're helping someone do that after 1 year has passed since their most recent entry, you need to have an argument for whether there's a changed circumstance or an extraordinary circumstance exception to the 1 year filing deadline. Because yes, there's a lot of fraud related to that issue. We could get into that if you'd like to, but you should have an argument for changed or extraordinary circumstances. They're in the regulations. If you want me to put in the chat, I can. But yeah, definitely be prepared to have an argument. I would not file if I did not have an argument.
Thank you.
Okay, let's move on to conflicts of interest. Danny, what is a conflict of interest?
Sure. So there are specific conflicts laid out in the Pennsylvania rules and most jurisdictions rules. But generally, what a conflict of interest is there's something, some circumstance, some personal interest, some other client that creates a significant risk that your representation of a client would be materially limited. So the classic.
You're silent.
Uh-oh, Danny. Yeah, we can't hear you. Can you all hear me?
Yes.
Yeah, okay. Can you hear us, Danny? Nope. Sure. Danny's in our attic. As I mentioned, we're married. Our kids are inside screaming real loud with my parents. So there's only so many places we can go. Sorry, everyone. But he's relocating. Jay Tinker. Sorry, I'm not sure what your first name is, but go ahead while we're waiting.
Hey Jen, it's Jennifer Tinker, and I gotta get that fixed. Every time I go to one of these, I forget to like fix my name on it. Um, so while we're waiting for Danny to come back, so for our pro bono attorneys who are going to be doing these things through one of our organizations that are going to be being mentored, can we expect that they'll be covered with the forms of our organizations? Because they are going to be mentored. Like say I send someone to you and then you like start working with Emily on an asylum. Can she then rely that she'll be covered by your paperwork, or do they have to have their own
You mean
prepared too?
our malpractice insurance?
Not just malpractice, but I was thinking like the forms for the people to sign that say this is going to be a limited representation. Um,
Yeah. So we at Arise, we keep things very controlled to make sure that quality is maintained and consistent. So we only the four of us, like myself and three DOJ reps, enter our appearances on behalf of clients. And then other folks can be very involved, but it's only the four of us representing clients right now.
okay.
Yeah. Because to handle an asylum case appropriately, there needs to be a high level of understanding, especially in this environment. At least that's our position. So we want to make sure we vet folks before they would take that on.
One more follow-up question while we're waiting for Danny to come back on. That was a good question about the 1 year.
Mhm.
Do you think that's going to be covered in any of the future trainings about arguments that can be made for change of circumstances for people that do file after 1 year? Is that going to be covered, do you think?
I can add it. I'll make a note now. Because we're doing some substantive trainings like on asylum law, and Danny's coming outside. And I can add that to those agendas.
Thanks.
Sure. So exceptions to the 1 year bar, changed and extraordinary. Great. Anything else, Jennifer? All right.
No, thanks, guys.
Come off and put us in the regular. There we go. Okay. Here
Sorry
we
about
go.
that, everybody.
No worries. Okay, so you're talking about conflicts of interest.
Right. So sorry, I don't know how much you heard, but generally, conflict of interest is some sort of circumstance, personal interest, or maybe another client that creates a significant risk that your representation might be materially limited. Um, so the classic example is you have two clients on opposite sides of a caption in a civil case or a contract, where something that you're required to do for one client, you're required to not do for another client. And as Jen was saying earlier, for reasons I have no uh, I can't possibly imagine, there's no conflict of interest rule in the Code of Federal Regulations.
Which is ridiculous. There should be.
Yeah, and the reason is there's immigration law is just chock full of multiple representations. You represent husband and wife, you represent employer and employee. It's just fraught with potential conflicts of interest that you need to be prepared for. Um, and you need to know what to do when they stop being a potential conflict of interest, they start being an actual one.
Yeah, and so like I like to dumb things down to make it easier for myself to understand, like ethics for dummies. I think of this as when your client's interests are no longer aligned, that's when you should start thinking, is there conflict of interest, right? Because a lot of times you represent families, couples, people whose interests are aligned, like they want the same thing. But when you enter into the picture things like divorce, or maybe there's a protective order filing, child against parent, one parent against the other, that's when the interests are no longer aligned, right? Those are like classic examples.
Exactly. And things can change. You know, sometimes you have an immigration client for 5 years, 10 years, and when they first come to you, everyone's on the same page, but things happen and they're no longer on the same page. And unfortunately, usually the way to cure a conflict of interest like that is you can no longer represent either of them.
Does anyone have any questions about conflicts?
Jen, I don't have this is Stephanie Albert. I
Hi.
actually have a question about the unauthorized practice law, if you wouldn't mind if we jumped
Go
back
for
to
it.
that. Um, I guess following up on, I think it was maybe Jennifer that asked that question about volunteers. So I guess just to keep it all clear. So, I'm an attorney, but so far, anything outside of the states that I'm licensed in, I've really just done volunteer work. And there's always been um, like an attorney of record that maybe I'm doing some research for or doing some of the draft writing, maybe an interview. But as far as being an attorney of record, I've never been that in a volunteer pro bono um, circumstance. So is it kind of the understanding that unless you're the attorney of record, the volunteers are not necessarily practicing law? Or kind of where do you draw that line? And again, I know you all are not giving us legal advice or anything like that, but just where does the line? That's something I've just been very careful about, of like where is the line drawn as far as
Yeah, so it's
I
a
mean, I
great
guess that you have to look at who's your client, but
Yeah, so there are a couple of glaring things that I think people who are not authorized to practice shouldn't be doing. I know you are a lawyer, so you can practice law, but giving legal advice, connecting facts to law or law to facts, like I would say that when you're doing that with a client, that's legal advice. Don't do it, right? That's
sure.
your example. So at Arise, there's a lot of reasons why we really rein things in. One of them is malpractice insurance. If we're going to have more lawyers, we just have to pay more money in malpractice insurance. Um, do you have any comments on that?
So I don't know if this is helpful to you, but I would direct you to the Code of Federal Regulations again. This is 8 CFR 1003.102 M. This is the body of law that Jen mentioned earlier um, that accredited reps are subject to. Um, it prohibits practitioners from assisting another person in the unauthorized practice of law, and then defines that as engaging in practice or preparation, as those are defined in the that same section. So practice is the definition I shared earlier, where it's using the
Mhm.
professional judgment, which forms to use. Preparation is filling in the form. Um, so I do think that it is a little broader than just the attorney of record. You can
Sure.
you can be practicing law and also not be the attorney of record on the case. Um, but it depends on case by case basis. Are you using professional judgment? Are you applying facts to laws? Um,
So,
Yes.
and in the immigration context, that's perfectly fine for somebody like me because I am a licensed attorney somewhere, in another state. But yeah, it just gets tricky of like when does it even gets outside of the area of immigration also. But anyway, that's a whole other topic. So
Yeah, and it's tough. I think there's ways that it's more clear when you're working on an actual case. So, like, since we do asylum, we do have non-lawyers or people who are not DOJ reps work with clients to help them write their affidavit. So, the way we would do that is we give the volunteer, hey, this is a list of what sounds like the client needs to talk about. We give a little bit of background, like this is why. And then that non-lawyer, non-DOJ rep, they just have a conversation and help the client tell their story. And they don't answer legal questions, right? They might
mhm.
give a little bit of explanation. I think that's fine, that's appropriate, but they don't like pose as someone who's an expert in the law. But they're still doing legal work that's kind of analogous to like what a paralegal would do at a law firm. And it's still hugely valuable. So that's why we do it. But it's tough. These are very gray.
Yeah. All right. Thank you.
Sure. Okay, so moving on to matter of Lozada. Big case, important ramifications. Danny will walk us through that.
Yeah, so we got a lot of complaints based on this case. This was a Board of Immigration Appeals case from the 80s. Essentially, what it says is if you're going to file a motion to reopen your removal proceedings based on your prior counsel's ineffectiveness, there's a couple hoops you have to jump through. You need to support that motion with an affidavit setting forth the agreement you have with this counsel that you allege was ineffective and explaining what they did or did not do that you claim was ineffective. You need to provide evidence that you notified your former counsel of the specific allegations of ineffectiveness, and if they responded, you're supposed to include their response, or if they didn't respond, you're supposed to explain that they didn't do so. And this is the one that always cracks me up. You have to explain whether a complaint was filed with the disciplinary authority, someone like me, or if not, an explanation of why not. So really, the requirement is you filed a complaint. Um, so we get a lot of these complaints. Usually, it's not something we move forward on. We have a policy generally where we won't really move forward on those complaints unless and until the motion to reopen is granted. And these are difficult motions to win. Um, so and there is a high standard. The decision says this itself. There's a high standard, and they set forth these specific requirements to deal with the large number of claims of ineffectiveness. Because if you're able to win a motion to reopen, it's great. You get a second bite at the apple. So a lot of people with removal orders want to file them. There's a Third Circuit case, Margarito Contreras, that stands for the proposition, and this is I think the consensus position across the circuit courts of appeal, that the claims of ineffective assistance of counsel are limited to the removal proceedings themselves. So pre-proceeding conduct is irrelevant for purposes of motion to reopen. And the Margarito Contreras case is really sad. It was a 245I case. If you're familiar, it was a great law that sunsetted, I believe, in 2001. So you had to get your application in before then, and this attorney blew that deadline, didn't get it in time. But it was an affirmative USCIS filing. So then the person was put in proceedings, ordered removed, and they tried to claim ineffective assistance based on their counsel's failure to file the 245I application. And the Third Circuit said, no, that didn't affect the fairness of the proceeding, which is what Lozada stands for. If you're going to make a claim of ineffective assistance of counsel, the real question is, did the counsel's performance undermine the fundamental fairness of the removal proceeding? And that's what you need to show to reopen a removal proceeding.
Yeah, so it's really tough for those of us who focus our practice on affirmative cases. We see a lot of fraud, a lot of what I would say is ineffective assistance of counsel. And it's very hard to deal with that because there's not this clear remedy that you have in removal proceedings, or at least an attempt at a remedy. I'll pause there. Comments, questions? Oh, go ahead, Emily.
So if um is this distinguished at all between ineffective assistance of counsel as in someone who is licensed to practice immigration law in some way versus notario fraud, for example, someone who is not licensed to practice law but maybe filed paperwork on behalf of an individual?
Yes, so that's actually our next topic, notario fraud. Let's cover what that is and let's circle back to this because maybe we can talk about something you're dealing with and something that's common. So notario fraud is generally when someone who's not authorized to practice law, immigration law, so someone who's not a DOJ rep, not a lawyer, holds themselves out to be authorized to practice law. So what we see commonly is notarios, they submit applications that are not winnable. So folks that really aren't eligible for asylum, for example, they submit asylum applications on behalf of those folks. They charge very high fees. Sometimes they are not authorized to submit something on behalf of a client, but they do it anyway. All these kinds of bizarre and really disturbing fact patterns come from notario cases. So, just thinking bigger picture, anytime you have a legally vulnerable population, like our clients, immigrants who face so many hurdles, you're going to get people, bad actors who exploit those vulnerabilities. That's why this happens. So, my encouragement to all of us is that we should be on the lookout for this stuff because it never presents clearly, right? Like no client has ever come up to me and said, I'm a victim of notario fraud. I need you to help me. It will always involve investigation and pushing back and doing things like FOIA requests to see what the record is, and other kinds of fact finding. So circling back to you, Emily, now that we've defined what notario fraud is, how do you deal with this? Is that kind of what you're getting at? Like in an affirmative context, if you know someone was taken advantage of, and someone already submitted a bad application for them, whether that's a lawyer, a DOJ rep, or someone posing as one of those two things, what do you do? Is that your question?
Yes, and my question is also twofold. The second part would be in the immigration court context, um, is like the remedy process or is matter of Lozada applicable the same way as it is for ineffective assistance of counsel?
Are you saying like can Lozada reach back into the affirmative context?
It's if there's notario fraud in the affirmative context, and then a separate question is if there has been notario fraud submitted, if a notario fraudulently submitted, or just if there was fraud that was submitted to the immigration court because client hired somebody who was not authorized to practice law, they posed themselves to be, um, since that person is not licensed, is matter of Lozada in the same way applicable to remedy this situation like it would be if that person who submitted this application had been licensed?
So, with regard to the second question, I am nearly positive the BIA published a case on this recently saying that Lozada does not extend to non-attorneys. Is this ringing a bell?
No, I was actually going to say the opposite. I thought it sounds
I'm
like a really
pretty
compelling motion to
sure
reopen.
I can, I will email you, Emily. There have been so many BIA decisions, but I'm pretty sure that that was a recent publication. I will follow up with you on that specifically. So to be continued on that. But in terms of like, what do you do for your client who's been a victim of fraud? It depends on how bad the fraud is. So on one kind of end of the spectrum, you have just real slop, like horribly assembled case. That might be fraud, right? Depending on what it contained. When I've had that, I have just flagged it for the government and I've told my client, like, don't swear to like affirm what is already in your record. We don't know what this lawyer filed because of a heavily redacted FOIA or whatever. We can't necessarily see what this lawyer already filed. So there's ways to practically handle it with the client, prepare them at the interview to say, look, I was represented by this person, they were shady, et cetera, right? And then you as the advocate also call it out at the interview. And so in the case of like sloppiness like that, um, it's a judgment call. Do you resubmit evidence, right? And run the risk of it maybe contradicting what was previously filed? That would be a problem. One thing that I have done is I've submitted a very generalized affidavit for a client who had already submitted an affidavit with another lawyer who did a terrible job. The idea being, okay, if we keep it general enough, it's unlikely to contradict what was already submitted, but we need to submit something. So there's so many ways you can handle that, like on that sloppy side of the spectrum, right? But then on the opposite side of the spectrum, you have like the highly concerning notario lied, submitted things that just weren't true. And that's trickier. I think first, we should report the person immediately. I'll put a link in the chat to the DOJ website where it talks about how you can report both notarios and attorneys and DOJ reps. So make sure you report, document what you reported. I would also file with the government, like with USCIS, what you reported and explain the situation. And I think, unfortunately, the best that you can do is just flag it, through the online system or through your paper-based mailing. And then also, it depends on the procedural posture of the case, but if you're called for an interview, bring a paper copy of what you filed, explain everything. If you had the chance to receive a FOIA, understand what's in the FOIA so you can supplement or correct the record, right? But it's really important when you're in front of the officer to explain what happened so that your client is not pinned with the fraud, because that could be, a path to deportation and possibly a permanent bar. And then if the officer doesn't know what's going on, because a lot of officers don't, has to speak to a supervisor and like notate in your notes, like make sure you're naming who these officers were, who the supervisor was, so that you have a full record of how you tried to report this fraud. Yeah. Do you have anything to add to that?
I don't know.
It's very tough because there isn't a clear-cut path like Lazada in an affirmative context. Okay, anything else? Go ahead. Sorry, someone said something.
Oh, I just said thank you.
Oh, of course.
Yeah.
Oh, go ahead, Tatiana.
Hi, I would like to ask about Lazada case. For some clients, it's not possible to reopen the case. Like Lazada may be just one way to do this, but for some ridiculous reason, Lazada requires the complaining disciplinary commission, whatever state it is. That's how I know this. Is there like how an attorney who worked with this case can protect herself or himself if the client wants to reopen the case and claims Lazada and has to file the disciplinary complaint? How should it work? How should we protect ourselves? Because in nowadays, reality is just crazy.
You want me to take that? That's Brenna.
So you're saying, how do you protect yourself from a frivolous Lazada claim down the line?
Well, yeah. It can be frivolous, but it also can be like mistakes. Like it's not necessarily that you you can have the wrong judgment, but reasonable, but maybe that it didn't lead to the right result, or maybe the government changed the policies or whatever happened, but the client still can file it. I wouldn't call it frivolous, but I wouldn't say that it was an effective representation of a counsel. The counsel could just have an opinion on how to represent the client, and he or she chose a strategy that didn't work, let's say.
Yeah, so a couple things. Number one is to have malpractice insurance, of course. Number two is if it happened to me, I would engage counsel for that, to make sure that I was explaining everything appropriately and protected. I think, from what I've seen of the ethics system, I think explanations go a long way if they are well reasoned, right? If it was reasonable, if the strategy decision was reasonable, I think it's far less likely that there would be any kind of discipline. So what Tatiana is talking about is when the system is abused, right? Because Lazada opens the door for a lot of people. And this has happened. Like immigration attorneys have had to deal with defending themselves against these complaints when they are frivolous, but they can also be gray, right? We can all make the wrong decision, and that's trickier. But I think the number one thing I would do if it were me is just to make sure that I hired representation, because these systems can be a little counterintuitive to navigate. So that's why I would want someone who specialized in that work, in that jurisdiction, representing me. I don't know if Dan even wants to touch that because that's the opposite of what he does.
Yeah, I mean, I would, like, I guess someone in my position would say something like this, but trust the process. If there's really a legitimate explanation for what happened, then you'll have an opportunity to explain that. And I actually have a story that's kind of relevant to this. I had a complaint against an immigration practitioner once. It wasn't a Lozada claim. I think it was an asylum case. And the complaint was that the lawyer didn't tell me when my interview was. I missed my interview. Now I have a removal order. Um, and the response I got from the attorney was, "Well, I moved offices." And I told USCIS I moved my office. I told them where to send the mail. I told them in writing. I told them several times. I put a forwarding in with the postal service, and none of that worked. It still went to my old address, and I didn't get it. Now, I I should have read that and thought, oh, this is the federal government. Give me a break. You told them that you moved offices, and they updated their system. But I've dealt with USCS a little bit. I know that actually that explanation tracks. Sometimes they screw stuff like that up, and it's actually not all that unusual. So that was a case where it looked really bad from the complaint I got, but when I I understand there's two sides of the story. When I got the attorney's response, I I thought it made sense, and that attorney didn't face any discipline for that because, as far as I could tell, he did nothing wrong.
Was he represented?
I don't think he was actually. I think he handled that one himself.
Okay.
But that is good advice. If you get a letter from my officer or a parallel office in another state, it is a good idea to engage counsel because there are certain things that you wouldn't know. It's a unique system. We have our own procedures. People who deal with our office all the time know better how to navigate stuff like that.
Thank you. And while I still have the microphone here, as I know, and it's written in many, social media, that attorneys are targeted now by federal government for the work they are doing, which can be appropriate. And when the government targets us because they want to remove people, how should we act in these circumstances right now?
You mean like a retaliation for practicing immigration law and helping immigrants? Is that what you mean?
Yeah, and Ayla actually reported the thing recently. They said like, yeah, we are targeting. They're just threaten us with with the complaints for fraudulent claims, and claim must like for the immigration benefits might not be fraudulent. It might be like reasonable, but we, instead of doing good work for our clients, we have to deal with protecting ourselves, and our energy and resources and time go to this direction instead of going where we have to, doing the actual work. So how can we, are there any advices that you can give right now?
It's really tough. I'm hearing about this too. I think there's a couple avenues. That Ayla's a great resource. Like you mentioned, I know a lot of attorneys have lawyered up for this reason. They have engaged large firms and developed procedures and policies to protect themselves in the event of something like this happening. Yeah, I don't have anything concrete to offer other than a little bit of encouragement with the federal courts. The federal courts have consistently ruled in favor of immigrants and ruled against this administration when it comes down to immigration issues. So, I think that's something to to be encouraged by, but I don't know. It's so vast. I'm hearing of very, very bizarre things like immigration lawyers being followed by ICE, right? Being followed home. And then other things like really invasive subpoenas for client records, which is illegal and very inappropriate. So I'm hearing, of all these types of things, but they require different responses. So it's really hard to weigh in on that.
It's a little outside my wheelhouse.
Yeah, the reason why I'm asking this is because I'm an immigrant myself, and because I'm gonna deal with someone with very vulnerable population, and it's like completely against the current administration policies to deport people that committed crimes, especially. And I'm I'm reasonably afraid of, like, any kind of retaliation. But I want to do this job because it's important and everyone deserves due process. But like, what should you do? Like, what should I do to protect myself if lawyers being followed by ICE? Like,
I
how
think
to
you
deal
should
with this?
talk to your administrators at your organization. That's usually where it starts, so that they can reach out to whomever would be helpful, whether that's a large law firm or someone who's focusing on these issues specifically, so that you can be protected. It's usually organization wide, is what I'm seeing, because there's different risks. Like, for example, I think folks who do removal defense work are more at risk than those of us who do affirmative work, right? So it's very specific to what you're doing, I think. I mean, it's a shame. That's not how you should have to think as a lawyer.
I know.
So I'm sorry you're dealing with that.
Oh, it's not happening, but I mean, everything I read is threatening. So
Mm-hmm.
I actually was thinking about whether I should accept this position or not. But I
Mm-hmm.
thought like I should do what I have to do, instead of being afraid of something. So
Right.
thank you.
Sure. Okay, couple other topics we have. So let's see. Can you talk about privilege?
Sure. So, and this is maybe something I should have mentioned back during the conflict of interest discussion, where um, if you have multiple representations, you have husband and wife, employer employee. One of the things that you should advise them to maybe get out in front of a conflict issue is that there's no secrets between. Um, if wife tells you something and says don't tell husband, that's not really an option for you. You can't keep secrets from your clients, particularly something that's relevant to their case. So that's something that I would encourage you to um, share with people at the beginning, so they don't put you in that position. Um, but privilege generally, anything that a client tells you in confidence, um, you can't reveal, you can't be compelled to reveal without their consent. And there's a one big exception to that is if there's a third party present during that communication, that would defeat the privilege. Um, another exception that came to mind during the last conversation was the crime fraud exception. So that's something to keep in mind as well. If I've noticed that's a theme with this particular enforcement regime. They call things crimes that maybe aren't really crimes. They call things fraud that maybe aren't really fraud. And maybe the reason they're doing that is because there's an exception to the attorney-client privilege, where if you can prove that the attorney was a participant or their services were used in some way in furtherance of a crime or fraud. Um, so what else should I say about privilege?
So we've had this come up when we're talking to, say, husband and wife, and they have either like a joint application for asylum, like one is the derivative of the other, or they have independent claims, right? And we're filing for them. And it makes sense to talk to both of them at once, right? But I know there's some folks on this call who have asked questions about that, because then privilege is waived, right? Is that how you would describe it?
If they're both your client.
Mm-hmm.
So my understanding is if they're both your client and there's no privilege between them, wife can compel you to tell them what husband said and vice versa. But outside of that, if someone from the outside, say the government, says, "What did husband tell you?" I think the privilege is still intact in that sense.
So if a third person's there,
Right. If the only people there are attorney and two clients, I think there is still privilege, just not among the clients. But if it's attorney, client, client, and then so and so off the street,
yeah,
then there's a third party present. There is no privilege
right,
because
okay.
the conversations weren't in confidence.
So, and we have that third person rando all the time in our cases, right? But it helps to have the third person rando there. We have them there for a reason. And so what's tricky is if you get into this and you try to explain this to the client, like, are you okay with the privilege ramifications with this person being there, blah, 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 blah. I mean, I understand half of this myself, so I don't know how we can convey this to clients, right? So it becomes very tricky and frankly a waste of time, I think.
Yeah, well, and until 18 months ago, it would be crazy to think that this would really be an issue. The government's not going to subpoena you for your case file, but now you have to think about this. If you get a subpoena for your case file, or if you're compelled in some proceeding to share what your client told you during a meeting, that's not really that far outside the realm of possibility anymore. So I think it is a conversation you should be having with your clients if you're afraid that some circumstance might defeat privilege somewhere down the line.
Yeah, it's really tough because the practical realities are that these kind of topics are almost impossible to explain to our clients just because of the level of sophistication required. Okay, circling back to Emily, I looked it up. Yes, Lozada does not apply to non-lawyers, unfortunately. Yeah,
That's a really upsetting decision. I,
yeah.
I can't imagine anything being undermining the fundamental fairness of a removal proceeding more than being represented by someone who's not authorized to do so.
Mm-hmm.
But hey, they didn't ask me.
So does that mean that there's just no remedy for it or potentially a different remedy?
The way I would look at it is that the onus is on us to make it up,
Yeah.
right? Because, we were talking through what that looks like and creative advocacy, because we can get creative even though there's not a clear pathway.
Mhm.
And there are still good people in the government who know that this is happening and who want to help. So if we're aggressive enough and we document enough and make it clear, I still think that there could be hope. It's just no one's carved the path for us.
That's a recent decision from the BIA.
I believe so.
Yeah, I wonder if there's a circuit out there that might disagree with that.
Yeah.
Yeah.
And because it's interesting to think about because uh, this whole idea of ineffective assistance of counsel, it comes out of the Fifth Amendment guarantee of due process, right? Which, like, we know that this administration doesn't believe in due process rights for immigrants. But of course we do, and these rights are ingrained in a lot of case law for immigrants. So they have just carved out, like if you read that BIA decision, they've just carved out like, well, these aren't lawyers. They can't be subject to ineffective assistance claims. Yeah, so it's really disturbing, but they've made that clear that that's their position. Yeah, so that's all we have for the agenda. Do you all have other comments, questions?
Jen, I have a question. I'm sorry, I can't seem to put up the hand. In terms of the logistics of reporting somebody, um, a general idea, what does it entail? And, can it be anonymous, not? What are the implications of it?
Yeah, so I put in the chat the website you can go to, and you can actually pull up the form. So if you go to attorney discipline is where I looked at the form, but I can just walk you through it. So you can click on that link and just browse at your convenience, but you generally have to disclose your own identity, right, as the complainant, and then provide evidence. If you want them to take it seriously, you have to give them evidence. And then you're really going to be on the hook for the investigation. So I know that much about the DOJ I'm sorry, the DOJ reporting process.
Yeah, so I can speak about my office. We really frown on anonymous complaints. Usually we don't even open on them. We won't even open a file because I need somebody to ask questions to. Um, so and Jen's description was pretty much what my office would expect, that you cooperate with the investigation going forward, and honestly, the ones that don't, we just close the file. Um, but beyond that, if it progresses to the point where I'm going to put the attorney on notice of your allegations, they're entitled to your information, your name and your mailing address. That's in our rules. And then if I'm going to pursue discipline, if I think it's something worth pursuing, I need to know that you're on board. You're going to cooperate. If I need you to testify, you're going to show up and testify. So yeah, I think there is a lot that we expect of the people who file the complaints, or if necessary, their clients. But yeah, generally we don't accept anonymous complaints.
I have a clarification question about privilege. It was helpful talking about, so two clients don't break privilege, like a husband and wife, but the random person off the street, does that include a translator? So does a
So
translator break privilege?
my understanding is that it does not. That if there's a
Okay,
third party present who's necessary for the representation, then that's not going to break the privilege.
got it. Yeah. Okay.
What's tough practically for us is like with our cases, we have a lot of helpful family friends who enable us to do our work, right? Because what we do is so complicated. And these wonderful people step up and volunteer their time and they want to kind of be the bridge, right? To help our clients get done what they need to get done. And so that person, that third person rando on the street, right? They would break privilege, but they're so helpful in other respects. So it's tough. Any other questions? All right. Well, thanks everyone. Thanks for bearing with us with the sound issues. Great to see you all. And we'll be on next week with on this topic, but talking more about client stories and situations. So have a great night, everyone.
Hey,
Bye.
Jen, can you hang in here for 1 second so I can ask you
Yeah,
some non-related follow-up questions?
sure. Let me,
Want me to hang out? Want me to leave?
whatever you want. I Zoom's being, because I'm trying to turn off the recording. Sorry. Lots of problems tonight.
I'll go in if you need me.
Sure, I'm good. Thank you. Sorry, Jennifer. I'm just trying to turn off the recording and now.
Take your time.
Whatever. I'll condense it. Oh, there we go.
All right. Thank you.
Thanks, Stephanie. Have a good night.